Hi and welcome to the latest in our series of 10-minute talks. My name is Beth Hale, I'm a partner at C.M. Murray and I'm joined by my brilliant partner Emma Bartlett. And we today are going to talk about microactivism in the workplace, what it is and what impact it has on workers' rights and the rights of the employer to take action about microactivism in the workplace. It's particularly topical today, which is the 16th of January, we're recording this, because the government have today proposed to introduce an amendment to the Public Order Bill to extend the rights of police to stop protests before they become disruptive. So if they suspect that it is going to, the particular protest is going to become disruptive to public order, then police will have additional powers to step in and make arrests where necessary. So it's quite an interesting time to be talking about activism, microactivism, and the sort of curtailments that there are on people's rights to protest. So we'll start with the very basics, Emma, if that's all right. What is microactivism? What does it mean?
So microactivism is small-scale protest. It's nothing more complex than that. And we've seen it, particularly in London, in the last few months with the Stop Oil protests. At one point, I remember seeing that there was less than a dozen people bringing traffic to a standstill in London by just walking slowly down the street. I think it was on the Strand they were doing it. And it's just bringing their concerns to the public interest by doing that. So other forms of microactivism we've seen is the Stop Oil graffiti in various parts of London as well, or where people have been sitting on the gantry of the motorways, a handful of people who are bringing their interest to the public awareness by disrupting what's happening elsewhere and inconveniencing other people.
That's interesting, isn't it? Because you call it microactivism, but it has a very big impact. That shouldn't, like, I think micro, yes, for the numbers of people involved in the actual protest, but it's obviously pretty major for the people who are potentially impacted. What protection is there for someone who wants to become a microactivist? So if you want to go and protest for the Stop Oil, what protection is there for you in the workplace?
So that's a really good question, and I think essentially we have to look at the Equality Act, which provides protection against discrimination, either on grounds of religion but also on grounds of belief. Religion and belief are defined in a very simplistic way in the Equality Act. Religious belief or lack of religious belief is something that's protected, and a belief or lack of a belief is also protected. A belief being something which is which was looked at in the 2010 Granger and Nicholson case, where the Employment Appeals Tribunal considered for the first time what a belief was that's capable of having this protection under the Equality Act. And it's a belief that is genuinely held. It's not just an opinion, it's got to have more than just a state of information that's available. It has to be a belief that is weighty and substantial, in relation to an aspect of human life and behaviour. It must attain a certain level of cogency, seriousness and cohesion and importance, and it is worthy of respect in a democratic society. So not incompatible with human dignity and not in conflict with fundamental rights of others. And finally, the tribunal in that case said that it had to have a similar status or cogency to a religious belief, but it need not allude to a fully fledged system of thought. So there have been some examples of what that was. If I refer to the Granger case itself, you'll know this well there. The claimant was arguing that he held a philosophical belief that mankind is heading towards catastrophic climate change, perhaps not too dissimilar to the Stop Oil protests, and therefore we were under a moral duty to lead our lives in a manner which mitigates or avoids catastrophe for the benefit of future generations. And he said that that was his philosophical belief and was one which the Employment Appeals Tribunal concluded fell within those categories. So the protection, in answer to your question, fundamentally sits under the Equality Act, that employers should not discriminate on grounds of religion or belief. And so it would require the employer to give some thought as to whether or not the belief that they believe their employee or worker is expressing in the workplace or expressing out of the workplace is something that they may have this protection under this part of the Equality Act.
And there's a difference, isn't there, which I think the lines often get blurred, and they are quite blurry lines, but there's a difference between the discrimination for holding the belief and then the sort of how those beliefs are manifested. Yes, the belief might be protected, but that doesn't give you an absolute free rein to manifest them in the workplace in any way that you want to. So it's that sort of that I think that blurry line is quite difficult for for anyone to sort of to judge, but I mean I think the tribunals have really struggled with it.
I would agree with that. There was a case involving a claimant who was an employee working at the YMCA, and he sought to convert people using the YMCA services to his own religion, which was Christianity, and his manager instructed him to stop. And so that was the manifestation of his belief, was trying to get others to convert to Christianity. And in that case, the employer had no objection to him being Christian. It was just the fact that he was trying to convert others. So
it's a tricky line to draw, though. So if an employer becomes aware that one of their members of staff is a microactivist, for example, a stop oil protester, or we're using them as an example because it's topical, but you know there are lots of other groups engaged in microactivism. So what can the employer do in those circumstances? They become aware that someone's taking part in these protests. What can they do about that if they want to do anything, indeed?
My view in the first instance is the employer has to ask themselves whether the employee's belief is impacting in any way the business or their relationships with colleagues in the workplace. So if the employer is aware by virtue of, I don't know, whatever, that this individual is a microactivist, is the individual in some way publicly linked to the employer? Is their activism linked to the employer? Does it in any way bring the employer's business into disrepute, for example? If it is, then potentially it becomes an employer's issue that they need to think about how to address. But if it isn't, if it's just the fact that this person is a microactivist, but actually they never bring the business into that, so they're not wearing a t-shirt with the employer's branding on, or a cap, or if they're posting on social media, they're not it's not saying I'm a worker at this, I work here. So there's no public link between them and the employer, then potentially whatever they do outside of the workplace may not be something which causes the employer concern, unless it impacts their relationship with colleagues. The employer can't take a knee-jerk reaction to this. It needs to think about how to respond. But does this person's microactivism mean that they are unable to work with certain colleagues because of this, or their position as a manager is somehow impacted negatively? And then you can see that that does become an employer's point of interest. But in answer to your question, I think the employer has to carefully consider whether it is impacting the business, poses a risk, and if it doesn't, then they don't need to do anything.
Yeah, I think it's a sort of tricky line to draw, isn't it? Because you use the example of someone wearing a kind of a C.M. Murray t-shirt to go and participate in this in protests, but actually there are lots of examples, aren't there, where if someone is named, or they are named, and then someone does a bit of digging, a journalist does a bit of digging, makes the connection between that person and the employer, which is really not difficult to do in this day and age. 30 years ago it would have been very difficult. Now you do a Google search for someone's name and you'll find their employer pretty quickly, probably. I think that link between the workplace and between what you do in work and what you do out of work is again much more. I hesitate to reuse the term blurry lines, but I think those lines are much blurrier than they used to be in terms of how you can connect people to their workplace and the impact that it has on their daily working life.
It's unfortunate, isn't it, if the individual hasn't actively been saying I belong to this workplace, but the digging by the journalist results that they are actually a member of Barclays Bank or something. The employer then has to take a view as to whether or not it needs to take some action, and it really does depend on whether this has brought the business or is likely to bring the business into disrepute, or whether an objective review is that, well, of course this person is more than not likely to be employed, and they're more than not likely to have an employer, but that doesn't mean that these are views shared by the employer, or that they're doing it in any way in the course of their employment or under the instruction of the employer. So there are pros and cons here, and if an employee is involved in some sort of microactivism, which is on the front page of the news, and it could result in some sort of criminal prosecution if they've breached a public order offence, the worker or the employee may be keen to keep the employer on side, because if it's more than likely that they're going to get a fine or be charged with something which could result in potentially, not always, but potentially a criminal prosecution, a sentencing, then they will want the employer to be able to say, okay, well, we need you to do your job and you're a valued employee and we'll give you a reference. It always comes back to the employer shouldn't have a knee-jerk reaction to this and should think carefully before disassociating themselves with the worker, not least because it could cause damage to any criminal defence to any criminal charges. But secondly, they have to think, am I doing this for the right reasons? Am I doing it because they are genuinely putting the business into disrepute, or am I doing this because I don't share their belief?
I think that's so difficult, isn't it? Because it does inevitably involve managers, employers making kind of moral judgments about people's the political stances or the sort of ethical stances that people are taking. If sort of it's very difficult for it not to come down to, do I agree with what they're protesting about?
Yeah.
And I think that's really, really hard, because there will be somewhere, someone might think, well, this is an absolute no-brainer. Of course, I agree with the principle, even if I don't agree with the way in which they're protesting. But there will be others where it's much more nuanced, and I think it's really hard judgment for employers to make.
And secondly, I do think the employer can limit disruption in the workplace if they become aware that somebody holds particular views, whether that's religion or a belief, in that they make it clear that there's no objection to them holding those views. It's just that they're not to proselytise them in the workplace. So don't try and convert others to your belief. Yeah,
you said that word very well. I always find it really difficult to say, so I'm not going to try and repeat it. But yeah, I think that's
glad I got it right.
You got it right, I think. Yeah, I think that's right. It's about, for employers, making sure that you make clear that your policy is not pro or against any particular set of beliefs. It is about respect in the workplace and everyone's beliefs being treated with respect. But then that links back to the sort of Granger test around what is a set of beliefs that is worthy of respect in a democratic society. And I think the bar is very high. The tribunals have suggested, the courts have suggested that the bar for not being worthy of respect in a democratic society is extremely high. So it's, I think ordinarily, even if you as an employer disagree with some views that your employees hold, it's you need to just remind everybody that it is about respect and tolerance, which is hard. You talked about a worker being sort of on the front page of the news. What if we were talking last week about the Brazilian parliament protests, which obviously didn't happen here and so aren't relevant to UK employers. Yeah. But what if the worker is reported in the press as being involved in microactivism?
So firstly, the employer needs to investigate. It may wish to use it. Well, it will have hopefully its own investigation procedures. So is it disciplinary? Do we need to suspend? And obviously remembering that suspension should be the last resort, because it, even though it's not supposed to be, it can still have a flavour of number one, it upsets people. Number two, it can give rise to an inference that actually they've done something wrong. And number three, when the individual comes back into the workplace after a period of time out, it can in itself damage the relationship. So do we need to suspend? Only in the most serious cases. However, we do need to investigate. So they follow their own investigation procedures. If we think about just looking at something which is not exactly microactivism, but where somebody did something outside of the workplace. So there was the incidence of somebody grabbing an MP in Regent's one of the London parks. I think it was St James.
It was they grabbed Chris Whitty, the chief medical officer, didn't they, in Hyde Park, I think. But yes,
in Hyde Park,
maybe even anyway, whichever park it was. It was a park.
And they were linked to I do believe that they lost their employment as a result, and we don't obviously know the ins and outs of it, but I believe some of it related to conduct which affected this individual's integrity. If you're working with other people and in the workplace, whether you're managing them or not, if there's a loss of trust and confidence in that person because of something that happens outside of the workplace, then that can lead to action being taken by the employer. But principally, Beth, it's an investigation, and you have to look at not taking a knee-jerk reaction, but understanding to what extent it may have impacted the employer's reputation or impacted their relationship with colleagues and ability to do their job.
And obviously there are particular issues, which I don't suggest we go into in detail here, for employers in regulated industries, so for lawyers, accountants, financial services, because of that issue of integrity that you so rightly raised, brings even more sort of issues alongside it. So thanks so much, Emma. That was really, really interesting. And thanks everyone for listening, and see you soon.
Thank you, Beth.